Hello, everyone. Again, I'm Professor Robert Romano, and welcome to Chapter 7 Contracts and E-Commerce. This week, we'll be talking about contracts, various forms of contracts. I'm going to posted a few various contracts for you to review, and some other e-commerce issues regarding contracts. All right, so as you can see, I'm still on the road, so I'm taping this from a different place than my office, but there may be some noise, there may be some interference, but we'll get through it. First off, there are two canons of interpretation that you need to be aware of when you are thinking about contracts, interpreting contracts, drafting contracts. The first one is courts try to interpret a contract as an integral whole in a way that makes sense for the entire contract. Okay? What that means is very simple. It means that, let's say you have a 20-page document, and on each page it says, this contract is effective July 1st, 2015. This contract is effective July 1st, 2015. This contract is effective July 1st, 2015. And then on the 18th or 19th page, it says this contract is goes into effect July 21st, 2015. Well, the court's not going to disavow the whole contract because of a typing error. All right, they're going to look at it and say, okay, all the parties know this was July 1st, not July 21st. Therefore, they're going to look at the whole contract as an integrated whole, and determine what makes sense. And it makes sense that it was to take effect on July 1st. They're not going to disavow the contract. They're going to say the contract is valid beginning July 1st, 2015. Second canon of interpretation is that if there is ever an ambiguity, a document will be interpreted most strictly against the party that drafted the document. An ambiguity meaning if there's a word or a sentence that can be taken two various ways. It can be interpreted A or it can be interpreted B. If a group of A drafted the document and B interprets the document to mean something else, that ambiguity means something else, the court will rule against the party that drafted the document. Reason being is they drafted it, they should have made it more clear. Okay? And since they didn't, they're the ones that are going to have to suffer the consequences. All right. What is a contract? When you think about that, we hear the term all the time. We sign contracts, we see contracts, we have an understanding of what contracts are. But think about it. What is a contract? Well, the book's definition is that it is an agreement between two or more parties that create obligations on both sides, and these obligations are enforceable or otherwise recognized under the law. So it's an agreement between two or more parties. It could be two parties, it could be 22 parties. All right, but it has to be two or more. You just can't make it a contract with yourself that create obligations on both sides. All right? The question becomes, what are parties? All right, a party can be a person, it can be a business, it can be the government. Is anybody legally obligated or legally entitled to enter into a contract? Okay? So a contract, an agreement between two or more parties creating obligations that are enforceable or otherwise recognized by law. All right, that'll definitely be on the quiz. We'll ask you a question, define the term contract, or I'll leave it blank. Is this a contract? That kind of thing. The contract, in order to be a valid contract, has to have five various elements. All right, all five of these need to be present in order to have a valid contract. The first one, those five elements are offer, acceptance, consideration, legality, and capacity. If you're missing any one of these elements, you do not have a valid contract. What is meant by the term offer? All right, we hear offer. Offer is a conditional promise. All right, it's a willingness to enter into certain terms with the intent to enter into a contract. All right, I offer you $50 for your cell phone. But we have an offer. We don't have a contract yet. We have an offer. From that point, it can be accepted or not, or there can be a counter offer. Okay, offers are good up until the time they are accepted. All right, unless they are revoked. An offeror can, at any time before acceptance, revoke the offer, as long as that revocation is communicated to the offeree. All right, you have to tell that person, listen, I want to offer you, $50 for those, for that phone. I changed my mind. I revoked the offer. Before it's accepted, that's fine, as long as you tell it to that person. Okay. That begs the question: what is acceptance? Acceptance is a final and unqualified expression of assenting to the terms of the offer. Yes, I'll take $50 for that phone, for my phone. Right? The only person that can accept the offer is the person to whom it was made. All right? So acceptance is saying, yes, I agree to your terms. I'll accept $50. If you say, no, I'll take 70, that's a counter offer. Now we're back at offer. Now it's up to the other party to accept or not accept. Okay? So you have offer, you have acceptance. The third part to a contract is consideration. Consideration is an exchange of value. One party has to give up something or do something in exchange for the other party doing a same or similar thing. They have to give up something or do something. There has to be an exchange of value. The consideration is an essential term needed to make a contract legally enforceable. All right, so both parties have to give up something. If you just say, here's my phone, take it, that's not a contract. You cannot sue to get that phone back at a later date. That would be considered a gift. Reason being, there was no exchange of value. All right? One person didn't give up something. You gave up the phone, but that other person didn't give up anything. They just took the phone. Now, if he said, here's my phone, give me $50, and they agree to it, they accept it, and then fail to make good on it, that would be something different. Okay? There needs to be some form of consideration in order to make a contract legal. The fourth element is legality. Right? You need legality in order for a contract to be legally enforceable. That means the underlying bargain, the underlying contract must be for a legal purpose, okay, to be considered valid by the courts. If it's for an illegal purpose, it's not a valid contract. All right, so think about that. What would be a form of an illegal contract? Well, gambling, maybe. Loan sharks, dealers, drug dealers. Those would all be illegal contracts, right? That's there for an illegal purpose. Gambling is illegal most of the time. Neighborhood dealers, that's an illegal transaction. An unlicensed professional would be for an illegal purpose. So if you contracted with an attorney who wasn't barred, that's not a legal contract. All right, that attorney needs to be barred in the state which they're practicing law. If they're not barred, they're not licensed. And if they're not licensed, they cannot enter into a contract. And any contract they enter into is not legal and therefore not valid. The fifth element is capacity. All right, what is meant by the term capacity? Capacity means the ability to understand the nature and effects of one's own acts. Okay? Minors do not have that understanding. Mentally incompetent people do not have that understanding. All right, anybody under the age of 18, the courts have said, cannot enter into contracts with certain conditions. Maybe under certain conditions they can, but for the most part, minors cannot enter into a contract. Mentally incompetent people cannot enter into a contract. All right, and if they do, it can be disavowed or disaffirmed. Right? It can be disaffirmed at a later time. So if the minor enters into a contract and it's going along, they could come in and disaffirm it at a later time. Okay? That's enough for this one. A question. Again, I'm going to put a question in the drop box for you. The question for this week is, where am I videotaping this presentation? Columbia University. It's Columbia in the background. This is Columbia University, so the answer would be Columbia. Okay? So if you want your point, put that in a Dropbox. Thank you. There'll be a Contract 2 video. Please check that out at a later time. Take care.